Members, the ayes are 61, the noes are 59. Part 4 is amended, will stand part. We now move to Part 5. The question is that Part 5 stand part. This is debate on clauses 70 to 74. The Honourable Ruth Dyson.
Mr Chairman, thank you very much. I just want to take a brief call in relation to Part 5 and actually ask the Minister to put on record the answer to one question that I have. I know the Minister in the chair isn't the Minister who's primarily responsible for it, but I assume because of her background that she's actually competent to answer it, so I'd really appreciate an answer to that. In the House last night we had one question to the Minister who is responsible for the legislation, which was in relation to whether or not he had a legal opinion about the breach of or potential breach of Bill of Rights in the SOP that he dumped on the country in relation to this bill on Easter Sunday. If the Minister and the Chair wanted to answer that question as well, that would be fantastic, but that's not the one I want her to answer. Almost the total purpose of Part 5 of the Crown Minerals Permitting and Crown Land Bill, almost the entire part is related to a simple change, which is changing the Order in Council provisions and regime, or the recommendation of the Minister, to replace by proclamation with that new term. And my question to the Minister is twofold. Firstly, why is that considered to be more appropriate in this legislation? Why is it more appropriate to have an Order in Council or the recommendation of the Minister rather than the current regime, which I assume has been in place since 1953, which is by proclamation? And the second part of that question, which is directly related, is this going to be the regime from now on? Are we going to see this sort of change in other legislation? And obviously, if that is the case, what is the driver for it? What is the benefit that we will see as a result of that change in procedure? So, Mr Chairman, as I said, I understand that Minister Adams is not the Minister who's primarily responsible for it, but I also know her background and consider that she would be able to answer that question quite easily, and therefore I'd greatly appreciate it if she did. If she has any information to share with the House which neither the Attorney-General, Chris Finlayson, nor the Minister primarily responsible for this legislation, the Honourable Simon Bridges, were able or willing to share with the House in relation to the legal opinion on the supplementary order paper in the name of Simon Bridges, then that would be even more greatly appreciated. So, Mr Chairman, that's the only question I want to ask, and I look forward to hearing from the Minister.
Catherine Delahunty.
Mr Chair,